I have like 18 windows open, so I'm trying to get them vaguely organized so that I can
Same.
But thank you for having me. My name is Meredith Jacob. I am the public lead for Creative Commons United States, and then I'm also the project director for the project on copyright and open licensing at American University. So I am a lawyer by training, but I spend most of my time talking to educators about copyright law and Creative Commons licenses and how the two interact to facilitate the creation of teaching materials, particularly OER. And so I'm here with you today to talk about two things. One is a question about sort of how to talk to people about licenses and copyright law in a way that gives them information rather than legal advice. And then to talk about some specific questions that people put into the chat or the document earlier this week and the week before. So as I said in my introduction, I'm a lawyer by training, but most of what I do is not giving legal advice. So it's very important to me when I talk to people like you on the phone or people in person at conferences or everyone out there on YouTube, that what I give is legal information. So information about what the law is, information about how it's applied to hypotheticals, information about how to think through problems, rather than giving people the conclusions to those questions. Because the answers, the conclusions, are really legal advice. And it's important for me not to do that because I am not individually or sort of as a group your lawyer. And it's important for you guys who are all experts about copyright and Creative Commons licenses in different ways in your own communities, right? You're in the CERT because in many situations, you're the librarian people go to with questions about CC licenses or questions about copyright. And it's important to balance giving them information that helps them come to the right conclusions or make good decisions with the fact that it's important for you to not give them individualized legal advice in the same way that if you've taken a wilderness first aid course, it's really good if you can tell your friends like, hey, I would definitely go see a doctor about that. Or normally if that happens to me, I wouldn't worry too much. I'd probably wash it and keep an eye on it. That you can give that sort of information, but that it's important to sort of keep a step back from giving advice. So I think that that's always sort of a hard place to start with because I'm saying like, hey, here's this thing you shouldn't do. But I actually think it's really important because you want other people to understand why they're making these choices. And there's lots of good information out there. And so I think it really helps build capacity in everyone you're working with to say, yes, that's a really important question. Here's the way I'd think through it. Here are the steps I would look at. Here are the resources. Here are some examples that are, documented that seem pretty clear. And that does two things. It reinforces for you why you think what you think. So it's not just a snap judgment. And for them, it builds out their understanding of how to make these decisions in other situations in the future. And then finally, it's sort of required by law and professional ethics. So there's sort of the reasons it's good for you, the reasons it's good for them, and the reasons that even if it weren't good for you and good for them, you have to do it anyway. So that being said, I'm going to try to model good behavior on that by talking through all of the questions and examples that have come up in the last 2 weeks of the course and give you information, legal information and hypotheticals to think through those without giving you the sort of legal hot takes of like, yes, legal, no, not legal, because that is exactly what I shouldn't do. And it is also coincidentally exactly what you shouldn't do. So does that sound like a good baseline to get started with?
That sounds great. And that might have been the best explanation of why we can't give legal advice I've ever heard. So
thank you.
I'm
getting better at this. The more webinars I do. I'll be able to do it in haiku, I think, by 2025.
Next webinar.
But I'm also aware, like in ways I was not before I started working in OER, about how bad the pedagogy is of me sitting here and talking at you for a 45-minute webinar. So I would really encourage people, if they have questions, to unmute and just like raise your hand or put them in the chat so that you save me from just talking for 50 minutes and then feeling bad about myself from a pedagogical standpoint. So hopping into the questions here, there's some that are sort of about copyright law itself. There's a question about copyright ownership. There's a question about the Berne Convention and registration. Then there's some questions about things that are sort of copyright adjacent, like FERPA, some questions about the licenses themselves, customizing the licenses, derivative licenses, databases and copyright, and attribution and citation. And I think what I'm going to try to do is start. Oh, hey, Maren.
Oops, sorry.
Hi, Meredith. So I just wanted to know, and I don't know if I'm jumping in and saying something that and messing things up, but like when Sarah did the Q&A a few weeks ago, she was able to address some of the questions that are at the beginning. So the questions, the 5, I think at the end, I think we might have covered FERPA, the FERPA question, but maybe we didn't cover that one at that Q&A. I'm just pointing out that there's some questions that are entirely new in this document compared to the last time. So that's, I think, starting with the FERPA release and CC question, possibly going downward, but obviously navigate this in whatever way feels best to you, Meredith. So
I'll start at the bottom and sort of work my way up, maybe. How about that? So the question that's last, I actually think is maybe a very important place to start, is the question about the difference between attribution and citation. And I think that's a really important question because it actually references something that I think is a huge core confusion in academia about copyright law, Creative Commons licenses, and citation and plagiarism. And there really is a bright line between things that are governed, well, legally. There's not a bright line out in the world, obviously, because I'm saying they're confused. But legally, there's a bright line between stuff that is governed by copyright law. So that is questions about fair use and questions about what attribution is required to satisfy the Creative Commons licenses. And those are questions about copyright law. And they're really separate from questions about plagiarism and citation and the academic norms about where stuff comes from. And so, for example, if you were writing a legal article, so the law has a system of citation that is, I don't have it, since I'm not in my actual office, I can't hold it up and shake it at you, but is defined by this thing called the Blue Book. It is horrible. Lawyers have written lots of articles about how horrible this citation standard is. It's so much worse than MLA or any of the scientific citation standards. Anyway, you have to use it in law review articles. And in law review articles, when you submit them, you get graded based on how accurate your citations are. So if I were citing a CC article, I would still use the citation format required by the Blue Book. If you're writing a paper that is in a discipline where you follow the MLA citation guidelines, you would use the MLA citation for an article if you were referencing a quote or an idea. And that's for 2 reasons. One is, in an academic article, if you're using a sentence, or in many situations, you're not actually using a verbatim quote at all, right? You're paraphrasing an idea. You don't get to needing the CC license. So the CC license comes farther down the chain. The first question is, am I even doing something that is a use under the Copyright Act? Am I using the thing? So if, for example, I'm talking about open pedagogy and I use Maren's idea, right? That open pedagogy is sharing power with students or whatever. Lawyers are not open pedagogy people. They like all the power at the front of the room. So I use Maren's idea. So then I would still need to cite to Maren's article, but I haven't done anything that is a use under copyright. So I use the MLA citation and I say, hey, I'm a responsible scholar. This is where I got this thing. even if I quote a sentence from Marin's article, quotation like that is a core fundamental thing protected by fair use. So I am, in theory, if I use like a 2 or 3 sentence quotation, I am using her work, right? I would be infringing her copyright if there weren't a limitation or exception. Of course, there is, right? Fair use protects all sorts of things, but among them, one of the things it obviously protects is quotation like that. So again, even though I quoted 3 sentences from Marin's work, I don't need to use the Creative Commons attribution to make that permissible. It's permissible under fair use. I don't get to that. So in the same way that I'm quoting anything else and I cite to it so that I'm meeting my ethical and academic professional responsibilities to say where that idea came from, probably the technical format requirements of where I publish, again, I cite. But then if I were putting together a OER open pedagogy reader, and I use Marin's whole article about open pedagogy for its original purpose, to teach about open pedagogy, so there I'm using the work under copyright. It doesn't fit into fair use or any other limitation and exception in the US. In other countries, in other common law countries, that's often fair dealing, which is related to but different than fair use. Or in countries that are civil law, you'll have more specific exemptions. So you might have education, you might have quotation, you might have private study. So in each of those situations, though, if I'm using her whole article for its original purpose, I probably don't fit within those limitations and exceptions. And so then I have the question of, okay, now I need copyright permission to do this. And the way I get that copyright permission is I comply with the terms of the license Marin has offered me, which is fundamentally what the CC licenses are. They're a license offer, really, to the whole public, saying, I, Marin, offer my article on open pedagogy to anybody out there who meets the terms of the license. And so if Marin's used the CC BY license, then if I want to use that license, I need to meet her terms. And so I need to provide the Creative Commons attribution. If for some reason I also felt like I needed to use the MLA attribution or the legal blue book attribution, I could do that. I would just do both. And I remind people that the title, author, source, and link standard is the standard for Creative Commons attribution, but it is not like a 100% formal standard. So if you were using the MLA standard, which clearly say the title and the author, but they might be like reversed in order. I don't know MLA, so I've been indoctrinated only into the blue book. Then you could use the MLA citation standard and then just include the link, the source link, and the license at the end of it in like a parenthetical. There's a question here about why you would do that. I am baffled by academic citation standards, and so I can't think of one off the top of my head. In most situations where you're incorporating it into another academic work, fair use is going to permit most of those. So in most situations where you're incorporating like if instead of an article, Marin had taken a photograph, and I'm using that photograph in my academic article because I'm directly critiquing it, in that situation, fair use will usually cover that. But I might decide, you know what, fair use covers it, but I'd still like to provide the CC license source. So I guess you don't really use that. You don't really use MLA citation for images. I don't know. Citation is, I think it's really mostly you would use them both in a belt and suspenders way, where you're like, maybe using this text is fair use, but I don't want to have to do the work to figure that out. So I'm just going to throw in the open license. Or I want other people to know that this thing I cited is openly licensed. Like you might do it for that signaling reason, right? It might be, I think Marin's article is great and I want to cite it, but I also want to know other people could find it and download it and distribute it. So I think the real answer is there aren't a lot of situations where you must use citation and attribution, but there are situations where you might want to. So, I think in a lot of open spaces, it's useful to signal to your readers this thing, if you want to distribute it to your students or host it on your own website or reuse it for your thing, is openly licensed. And including the CC license information will do that work. Does that answer your question, Suzanne, or is there a different situation you're thinking about?
Sounds like it.
Yeah,
Sounds like it does. I also wanted to. Oh, go ahead. Oh, I also wanted to note that your point really resonates because it applies to countries that don't have fair use or fair dealing. So if you don't have a limitation or exception to copyright, then you would need to abide by the permissions, and most likely it'd be good to cite too, so you're not plagiarizing.
Yeah, I mean, in almost every jurisdiction, you'll have, I mean, I think in every jurisdiction, the quotation right is mandatory under the Berne Convention, so every jurisdiction will have a quotation. So this will probably come up in situations where you might be making more extensive use of it than you think your national law quotation exemption might cover, for example. But the good news is, I would not say the Berne Convention has given us much good news, but one of the things it does mean is that every country's national law has a quotation exemption. There's also a question here, the follow-up is like, when in doubt, it seems citation and license statement is safest. And I would just push back on that a little bit. I think sometimes, this is another area where norms around plagiarism, I think, creep into our sort of first impressions about copyright law. So in plagiarism, since you're telling people where your ideas came from or who else you were reading, there's really no downside to sort of being overly cautious or overly cited, right? You're like, well, I cited in this sentence, like, in legal writing, you cite basically every sentence. And so people get into this norm of like, when in doubt, add a citation. I put this on the sentence before, but I'll put it on this sentence too. And that's okay because norms around plagiarism are sort of flexible and responsive to the field and don't pose really big hurdles to the ability to do scholarship. But copyright law, particularly copyright law in the US, is this really calculated balance designed to incentivize creation. And it includes really strong protections, but it also includes really strong users' rights. And I think sometimes people, informed by their sort of previous experiences with things like, try to sort of modeling good citizenship around attribution, let that creep over into their understandings about fair use and sort of create this baseline idea that, when in doubt, avoid fair use, or when in doubt, don't do that. And I think the law has this exception for a reason, because without the exception, the protections are too restrictive. And so to the extent that teachers and professors and librarians purposely avoid the users' rights that are built into the law, it contributes to this imbalance where the protections are too strong and not balanced out by those user rights. So it's one of those areas where I think, when in doubt, you can always cite, you can always, if you want to include both the attribution and the citation, that's fine. But I would just not let that over caution keep you from relying on fair use when it's appropriate, because fair use and the licenses really work in complement to provide users and students and authors with access to knowledge goods. So there's a question here. So about academic norms around citation privilege ideas, while rules around copyright and CC attribution privileges expression, it's really that copyright protects expression. So unless you are doing something with the expressive content itself, copyright doesn't care. And yeah, attribution comes down to the where did you get your ideas from? So they're really sort of separate domains. I mean, also I think, the academic norms around what is the appropriate citation are really different, sort of field to field and level of education to level of education. The amount of citation you would do in a popular article versus a law review article, for example, are completely different. The standard for a law review article is it should be 1/3 text to 2/3 footnotes, which would be insane and unreadable in a popular press article. And so that's really fluid in the way that copyright law is very sort of black and white. So in the interest of not talking only about plagiarism and citation, which I could do, I'm going to move on to another question, which is, in the summit this week, there's been a lot of discussion about copyright, AI, surveillance capitalism, and sort of all of these big data ideas. And there's questions here about the databases being treated differently in different jurisdictions. So copyright law is, about rough numbers, 100, 150 years old. And so a lot of our sort of legal understandings, well, copyright law is older than that. Copyright law in its sort of modern form is about 150 years old, maybe. A lot of our understandings about what is protected and what is valuable are old, right? There's copyright, in the Constitution, it's, useful sciences, I don't remember the phrase, but so there's this old idea about human perceptible stuff. And so as databases began to be valuable, this idea that data what was valuable, not necessarily expressive content, different law dealt with that differently because it came in sort of late in the process. So in the US, we don't have protections for data as data. So factual information unprotected by copyright. Some jurisdictions have protections for databases, so collections of data, as a separate standalone law. And then in the US, we protect arrangements and selections of data to the degree there's authorial choice in that. And so because there is so much variation in how data is protected, and sort of what is the line between a data, like just a set of data, a database, and like a specific arrangement of data. Generally what we recommend at CC is that you use the CC0 license for data sets and databases. And that's for two reasons. One is it means that in a jurisdiction like the US, where there may be no copyright in that data, you're not claiming copyright by requiring attribution. Like you shouldn't put a CC license on something that is not protectable by copyright, right? Because you are sort of implying I have copyright, but I'm giving you the license. And if what I had was just like a list of time and temperature, like at 9 a.m. it was 70 degrees, at 10 a.m. it was 72 degrees. In the US, that data is probably not protectable by copyright. I mean, it's not. And so if I put a CC BY license on that, I'm sort of overclaiming. It's not the end of the world, but it's something to avoid doing. And then in other jurisdictions, at the same time, if I put no license, they may not feel free to use it. So generally what we recommend is to use the CC0 license. This also avoids problems with attribution that can come when you're trying to attribute individual datum in large combined data sets. So, if I'm imagining combining 4 or 5 CC licensed texts into a new textbook, it's not hard to think through the attribution problems. How do I attribute, what is this article versus that article, right? Like there's this one and then there's that one and then there's this picture, and you could like imagine pretty easily how to label each of those. But when you're combining data sets, particularly when data sets get combined and redistributed, it can be very hard to sort of technically meet the attribution requirement of the CC BY license as those data sets get combined. And there's this idea of like, well, do people own the copyright in the set or the data? And by using the CC0 license, you aren't imposing this attribution requirement on the data set that A, may not be legally enforceable, and B, can make the reuse of that data a lot harder. Does that answer the database question? The other question I think that's maybe implied here is, what do we do to keep bad people from doing bad stuff? And I think that that question comes up a lot in people's initial inclinations about which licenses to use. And I'm a big proponent that it is way more important to use a license that enables the people you want to help, the people you want to work with, and the people you want to enable to do everything they need to do, and to orient your license decision around that, rather than the sort of defensive license choice of saying, I am worried about these bad people doing this thing, and I'm going to try to pick a license to prevent that. And that's for two reasons. One is, it is way more likely, in my opinion, that when you pick a more restrictive license, like a NC-SA license, or trying to put a license on data that prevents its use for specific purposes, that you're going to cause interoperability problems or confusion or put up roadblocks for people who want to do positive things, and a lot less likely that you will fundamentally protect from those things. And that's for two reasons. One is, I think they're pretty rare, and two is, when they do happen, it's often not copyright that's the correct hook. So I know there was some questions about CC licensed photo sets used for facial recognition AI. I think that was discussed last year at Wikimedia, and at least in the US, using images to make an AI like that is legally very similar to like search, and it's this sort of non-consumptive research, is probably completely enabled by fair use. And so while the open license might be a way that they had access to sort of easily say, yep, just pull that in, it's sort of the belt and suspenders approach, in a lot of situations, the worries that we have about AI and surveillance are not things that can be protected against through licensing, which doesn't mean they aren't things that the open community should push back against, just that licenses are not usually going to be the most powerful tool in that toolkit. Does that sort of get to that question? I don't know who put it in. I don't know if they're on the call, but that would be sort of my answer for that. So here's a question about share alike and derivatives. And so it says, I need some help in understanding share alike. Is it true that I can use share alike material unmodified, such as a photo in my article, and license the article I have written CC by? It's implied that since I would have marked the image CC by SA, it continues to be CC by SA, and the article would be CC by. So, and then there's a second example. If I'm writing a chapter and I use a couple complete paragraphs from a share alike article, can I license that portion share alike while the whole chapter is CC by? So the question here is whether or not you've created a derivative work for the purpose of the license. And I would say that, you know, the question sort of is, you know, are you creating a new intermixed thing that's sort of hard to separate out? Or are you really creating something that is more like a playlist where things are set one after each other in chunks? Generally, though the question about what is a derivative work is a sort of jurisdiction-specific question, I would say that from the sort of Creative Commons norms, that the first example of taking a share-alike image and setting it alongside text is permissible, right? That you can say, look, here's this image, it has its own copyright, it's its own author, right? It has its own license that continues forward. I'm not the author, I'm not creating a new thing, there's that image. And then I've set it alongside text. And so that text could be CC by. It would be important, as it is, I think, usually, to put in your front material, except where otherwise noted, this text is CC by. And depending on the format of what you're creating, you could list those other things in the front matter, or for a larger resource like a textbook, you could just make sure they're labeled under each object. That's a sort of judgment call about how your format style works. But I think in that situation, strictly the derivative question is a national law copyright question, that pretty much lines up with CC norms. The second one is a lot closer to the line for me. You know, I think to me, it would really come down to, in the sort of narrative structure of your text, if you're using those paragraphs sort of in the flow of your text, and you're really creating one thing, even though you can mark where it starts and mark where it finishes in terms of that section, if what you're creating is one sort of narrative text, then that to me is not nearly as clear. And I would not feel confident telling someone, no, you don't need to have one license for that. You don't need to meet the share alike license term. And so in that situation, I think you might need to use one license. I don't think it's clear, but I wouldn't feel confident saying no, you don't. An example maybe where that would be different would be if you had it in a pull out text box where it was clear this was a separate resource, it wasn't part of the main thing. Again, it's hard to say. That might still be a derivative under US copyright law, but it would be much closer to the line, and I think would also sort of separately line up a lot closer to the norms of what people expect and don't expect from share alike. And the other thing I would say there is these questions and the sort of worries they pose for people are one of the reasons that I personally, rather than with a CC hat on, advocate for people to start with the default of CC BY, unless you have a really convincing reason not to. I think that, you know, the general ethic of share alike, of that I would like people who use my stuff to share, is often very valuable. But there are sort of specific situations where, for example, if you're at a university that requires one license, you know, sort of famously, like MIT OpenCourseWare is all CC BY and CSA, where, you know, and I think, or, you know, I can't remember whether Wikipedia, I think, is CC BY SA without the NC, right? So now you have this conflict where, for everyone's best intentions, the Wikipedia content and the MIT content are now not mixable. And so I think that's an example of where well-intentioned first steps create these conflicts. And so I would encourage people to consider CC BY as the default, unless you actually have a plan to commercialize your own content. You know, thinking of the NC license as a way to reserve your own right to commercialize, I think is a lot more accurate than thinking about the NC license as sort of a shield against bad actors. So there's a question here about customizing CC licenses and additional restrictions. So the course content indicates that customized CC licenses can't be called licenses and can't use CC trademarks. And I would sort of clarify that. They can't be called CC licenses, right? You can customize and write your own license, but it's not a Creative Commons license. The second question, which is, does the customization render the legal enforceability of the license invalid? No, it does not. It can't be called a CC license. That is true. But CC licensing is basically it's a trademark, and it's sort of a way to label these as standard open copyright licenses. And that standardization piece does a lot of work, and it's why CC doesn't allow people to use the CC name and then add customizations. Because sort of a core part of the sort of CC bargain is that everyone out there says, okay, if I'm going to use the CC license, I'm not going to alter the terms. But then that means for users, if I see that it says CC BY or CC BY SA, I know what that means. And I don't need to dig in and read the red line version and try to understand what the changes mean. If I read and understand CC BY once, then every time I see it, I know what that means. And so if you're going to change what it means, if you're going to add additional terms, that's why you can't use the Creative Commons license name or the label or the image. But as you're doing that, you're not fundamentally breaking the underlying language. So if we believe a CC license is valid, right? And at some level, the license is really the legal deed, not the sentence, right? So, but if we believe that that legal deed works and is enforceable, then when you add conditions to it, it's presumably still enforceable, because in neither situation is Creative Commons a party. So if I use Marin's CC licensed article and I don't attribute it, Marin can't complain she can complain to Creative Commons, but it won't do her very much good. Marin's choices are to write me a letter and say, hey, stop that, or to sue me for copyright infringement. And in neither of the situations does Creative Commons really act as a party to that. And so if you write your own license based on the CC licenses, they have this, presuming that you do a good job in drafting, they would have the same legal enforceability as the CC licenses, but they're confusing to other people and you can't call them CC. There's a second half to the question. It says, adding restrictions to this, would adding restrictions to the CC license have the same result? Does that mean the restrictions aren't enforceable? Does it mean there are separate agreements that place restrictions on the license where the CC license is no longer enforceable? So no, I mean, the enforceability, the Creative Commons brand doesn't give the licenses a special legal status. You know, it might give you a little better argument if you use the CC license and people are regularly using CC license stuff that they understood or should understand what they're agreeing to. But legally, you know, the CC brand on the license doesn't give them like a special legal status. Does that answer that question? It's a sort of complicated question. I'm not sure I got all the pieces. Okay, I hope that's useful. And I mean, I think the other reason we just generally encourage people not to add restrictions to the CC licenses, I mean, we require it, but the reason that that is a valid thing is that the standardization is so important. That for users to understand what they are agreeing to, and then for different types of content to be interoperable, those two things are so valuable that we think they really outweigh the, yes, but I would like it this plus 10%. The flip side of that to me too is that if you really do not agree with the permissions given by the CC licenses, I would encourage you not to use them. You know, there are situations where other considerations, so considerations about privacy, considerations about dignity, considerations about traditional cultural knowledge might come into play. And if you really don't want things to be widely shared and reused, and you don't want to give up that control, I would really caution you not to use the CC licenses in those situations because, you know, whatever sort of requests you might add in, fundamentally the CC licenses communicate to the public, both legally, but also through a lot of hard work on everybody in the sort of open spaces part, you're free to go out and do what you want with this. And so if you fundamentally don't feel that way about something for non-copyright reasons, then I would not try to use a CC license with additional restrictions. I would leave that under all rights reserved copyright. And that might be a situation where people either rely on fair use or they rely on individual permission. I don't think those are most situations, but around the margins where those exist, I actually think the CC licenses can cause confusion. There's a question about a FERPA release form and a CC license option. That is a complicated sort of fact-specific legal question that I would really need to see the form and give you advice about, which would not be the thing I do. You know, FERPA is generally a privacy question. Broadly speaking, FERPA protects student privacy. You know, I think the second part of the question doesn't make it, the parts of the question don't totally track, right? So there's the first question that is, do I have permission under FERPA? That's really a privacy permission. Second part of the question is the student didn't give the university permission to give their work, but they did mark a CC option, and those two sort of, so the student could still be the author, and the student could give permission to post, if that clause was written correctly, you could say, I, the student, agree to license my work under a CC license. So in that situation, each student who contributed might retain the copyright to their work or might retain the copyright interest in their joint work, but agree to license it under the open license. So under the CC license. So in that situation, the university wouldn't hold copyright. The student would keep copyright, but the student has agreed to license it under the CC license. But you'd need to write that clause to make that clear, and I sort of can't tell here about how that would be drafted. But I do think it's important to decide that up front. There is also separately some law in the US at least, about volunteer contributions being treated as work for hire. So, there are some situations where people contribute to a volunteer project that's considered work for hire and they don't retain the copyright to that. So you don't need that sort of belt and suspenders. But I would say up front, it's generally useful to get clear agreement that people are, whether or not they're transferring their copyright, and if they're not transferring their copyright, whether or not they license it under the open license. And in there, you want to say they do license, not like they agree to do it in the future. You want to have it sort of done at the outset. There's a question in the chat that says, yeah, it's a question about what about having sort of one-off licenses, like, the My Brand open license. And I totally agree. Basically, it says, you don't want, one of the reasons that the CC licenses are really valuable is, in addition to them being standardized so that people know what's in them, they've been tested for a long time, right? They've been used for almost 20 years. And so you can assume that there aren't these sort of traps for the unwary, that there aren't sort of things in there that you haven't found in the small print, that enough other people have read them, that you're assured a certain predictability and reliability there. There's a question in the chat about whether student work is considered work for hire. I don't know the answer to that. I would not presume to tell you. This is just sort of broadly sometimes, like in volunteer contexts, that can be something that comes up. But I would not assume that. Like, it's mostly student work has separate legal coverage in how it's treated. And so I would make sure that you know what your K through 12 policy is or your university policy is, and that you have agreements there. And in K through 12, it's important to remember that it may not be the student's agreement you need, it might be the student's parents. And so one of the things that I don't know if CC really has, but might be useful for different CC affiliates, or sorry, CC chapters to do, is to think through what those agreements might look like in different jurisdictions, so that you have a sort of model agreement that says this is how people who are contributors in a project can agree to license their work. Wikipedia has sort of the standard language when you contribute to Wikipedia that you agree to. And in our work with the Open Textbook Library, the Open Education Network, we worked with them to draft a standard author agreement that includes language about copyright that you could adapt to a student contribution model.
That's a great idea. I just wanted to jump in, recognizing we have about 15 minutes left. There was a question earlier on in the chat from Jennifer Halsey Campbell. She was asking about the differences between the versions, so CC BY 2.0, 3.0, and 4.0. I was wondering if you wanted to take that or any of the other.
So the question about what's different in the versions is, I don't really know what the differences in the versions are. Like, I think basically, my understanding is there's a difference, I think, between, I don't know if it's between 3 and 4 about the ability to cure a failure to license. So it's become somewhat easier if you were licensing something, if you were attributing something incorrectly, and someone writes you a letter and is like, hey, you've done this wrong, it gives you more of an ability to cure that. And it doesn't erase backwards looking consequences, but it reduces their ability to keep you from using it going forward. So there's some stuff about ability to cure in there. They're not substantially different. I think there are some details there, but for most users, there are not significant differences between the licenses. There is, someone pointed out in the chat, there's a very big breakdown of the differences, but if people ask me what the differences are between the license, I would say I don't really know what the specific differences are, but they've been updated to sort of fix use cases where people's expectations didn't line up with the text of the license.
Thank you. All right.
Here's a question. if you're adapting a work with the specialized license, can you put it under a CC license in the new work? So these questions about license compatibility are very complicated. Diane Peters, the General Counsel for Creative Commons, has done a lot of very smart work about license compatibility. There are questions, some of them are copyright license questions. There's also questions about like the interoperability of the CC licenses, which are primarily used for human readable content, and then the open source software licenses, which are primarily used for software. And then there's some open database licenses, but because these things are messy, there's a Venn diagram of those three sort of universes of licenses that overlap. And so Diane has done a lot of very smart, very hard work on the license interoperability there, which is to say that is not a simple question. And another reason to sort of avoid overlap between licensed universes. So like if you're writing software, use software licenses. If you're making a database, either use CC0, which is very compatible with everything because it implies, it's the closest to a public domain dedication as we can get, or use a dedicated database license. And if you're using content, use the CC licenses and don't write homebrew ones, because license compatibility is very unpleasant. And I'm glad Diane does it and not me. Any other questions? Maren?
Yeah, so Meredith, backstory to this. So there was a question asked by a participant in my section this semester or this term, Savithri, who actually is on the call, but because it's like 9 p.m. where Savithri is or around there, I was like, I'll just throw your question into this Q&A document because we're having this session right now. She was just asking me personally. That was the question way back when that you were answering about essay and derivatives. And then I tried to paraphrase the second portion of her question. So that got missed, I think, maybe by you when you were, or maybe you were answering both portions in your first, in what you shared, but basically it's because of the page break, the question continues on the second page. And I think basically the gist of what Savithri is asking in that portion is sort of like about quantity used, and at what point does an amount of quantity of someone else's work that's getting incorporated into your work, but you're using it verbatim, become then like render your use of their work a derivative work. But Savithri is actually on the call, so I wonder if So she is. Okay. So I wonder if Savithri wants to jump in and say something about that question, or if I reflected it accurately just now, what you're asking in that second portion. Yeah, I just want to come back to that since that part got missed, I think.
Thank you, Maren. Can you hear me?
Yep.
Yeah, okay. So there is a second part that basically, yes, when we verbatim take portions from somebody else's and put it into your own work, at what point does it become a modification? And I mean, do you lose credit because I use 30% of your work and I kept 70% mine? So if it becomes a modification, then it becomes somebody else's work, isn't it?
Yeah, so I think there's sort of a couple of different things mixed in there, right? So going back to the very beginning of the call, if you're using a very small amount of someone's work, like 3 or 4 sentences, and you're in a jurisdiction that has quotation right or fair use, you don't need to worry about the share alike license term at all, because you don't get to the license. If you're using something like a photograph where you're not created a melded thing, you can let those two sit aside. But then once you're incorporating their text into your text at a sort of paragraph by paragraph level, that's going to be a derivative work in most jurisdictions. And so then you do need one license. That doesn't affect questions about who is the author of that new work. You would still be the author of the work, and that whole work would be the whole new work would be attributed to you. It would just need to be under the technical license type of CC by SA from that SA content. Because what SA licenses say to the world is, if you need my license, so if you do something that is enough to need the copyright license, and you're making a derivative work, then that whole derivative has to be licensed under my exact license type. So you would still be, from an authorship standpoint, the author of that book, for example. If you wrote a book and you used 20 paragraphs of CC licensed content in your 200-page book, you're clearly the author of that book, but the license type might be required to be SA if you'd really melded that SA content in there so that it was a derivative work. So that's the sort of way that authorship and attribution are only sort of non-intersecting with copyright, and then when copyright law requires the CC licenses to do their work. Does that answer that question?
I have another bit. Supposing you've written a story and I add cartoons to it, okay, or I add some images. Can I now publish that book as a CC by if you published your story as CC by SC?
That is a very sort of jurisdiction specific question. Generally, the answer I think there would be no. That if you're using cartoons to sort of verbatim tell the story that I have told, you are creating a derivative work, and then you would need to use that original license. So you would need to use the CC by SA license on your new work, and you would need to attribute back where the story came from. That's also true in translations. So translations are another category of derivative work. So if you have an SA license on something and you create a translation, you would need an SA license on the translation as well. There was a question in here about student competitions and student competitions requiring people to transfer copyright. There's a lot of sort of different, I would say, extractive situations where we require people to transfer copyright. And it would be great if in those situations, you push them to accept a CC BY license instead, right? Because a CC BY license lets them do all of the things that they would need to do, but does not transfer the copyright. And so, you know, in the questions about student contributions, again, you could say, you know, here's a publishing agreement, here are the student contributions. We're not going to require students to transfer their copyright, but we are going to ask that they be CC BY. So in that way, you let the students retain control and authorship, but you don't limit your ability to do that. The only other thing I would say is, to the extent that you're creating OER that may go forward, it's important to consider whether or not you have all the permissions you need about updating to new, whether you need permission. It's unclear whether or not you'd want to get permission to like update to new license types or relicense or things like that. But I think that generally the CC BY licenses are a great way to diffuse questions that often come up about who owns something, because both parties can still make full use of the work. In K through 12, this often comes up. Most K through 12 teachers have employment contracts where the district owns the teaching materials they create in the course of their employment, at least in the US. And this can create tension because teachers just, you know, want to own their work they created. And the district, you know, asserts in the contracts they own it. And so the CC BY licenses can be really powerful there, because it means that even if technically the copyright passes to the district, the teacher retains the ability to use that work going forward and can be listed as an author, and it can give you that shared control and credit. There's a question here. So my statement was not that CC chapters do have those, but I just think that this would be a useful project, is for CC chapters to work through like what are the questions that people have, what are the things that show up in practice, and work with you know, both educators and then also lawyers, right? Like it's important to work with educators to make sure that you write these in a way that lines up with student expectations. And then it's important to work with lawyers in your jurisdiction to make sure that you understand whatever the law is about student work at a default, about how you would get permission for work created by minor students, all that sort of stuff. And you want to bring sort of the lawyer piece and the educator piece together to come up with models there. And generally, if you're using them, you'd need to make sure that your university policies also line up with them. So there'll be this third piece of sort of making sure it all fits.
Yeah, I realized that you were mentioning that as a like an idea for the future of something that CC could encourage, but yeah, and I misstated that. I was meaning that that could be added on as these other scenarios, like not only those in which faculty might be working with students on open pedagogy type projects, but those in which, like we had a hackathon at my school recently, and students just handed over all of their IP, and there was absolutely, and I expressed concern about it to the administration, and kind of was looked at not so kindly for doing that. But I think there are a lot of us who have like are on the front lines of those sorts of, you know, circumstances and cases all around the world and are trying to fight these battles, you know, and not battles, that's not the right way of saying it, you know, but we're kind of going into these conversations a little cold just with our, you know, like CC, you know, passion and a little bit of knowledge as a part of our tool belt. And if we could come together as chapters or within chapters and across chapters to build some templates and talking points on these things particularly, I'll be like the first to sign up for something like that to help out with a project like that. I would, yeah. So,
and that's an example where the questions about what you address are going to be really reproducible chapter to chapter, and the language about how you address them would not be. So, like in the US, for example, you wouldn't want to say students agree to license, you would want to say students license, right? Because that's like a point of US copyright or contract drafting law. But that might not be how you did it in a different jurisdiction. So that language would be something you'd work on your jurisdiction with, but the questions would be the same. And there again, it would be important to say, like, you might separate, here's how we give credit with here's how we do licensing. You know, I think it's important to those two don't have to be 100% bound up, questions about credit and questions about licensing. I would also encourage people to look at the OEN model for now, the Open Education Network standard publishing agreement is a really good model, at least to start, and just gives you an idea of sort of what stuff might be covered.
Sorry, you said the OEN publishing agreement?
There's an OEN model publishing agreement. Yeah, I can find it.
Thanks, I'm looking for it right now too. I'm realizing we are at the top of the hour just about, and we had so much great, I don't want to say legal advice, we had so much great input from you. Yeah, you definitely walked the walk. Thank you so much for walking us through particulars on SA licenses and fair use and fair dealing and so much more. This has been a really wonderful webinar. I don't know if you have one last comment or if you want to take one last question, but I just wanted to jump in and say a big thank you for all of your input and also introducing yourself and reading the questions yourself. You made my job very easy.
Of course. No, thank you all for being here. Thanks for taking the time to take the certificate and for all your hard work.
All right. Thank you. And yeah, thanks to everybody here. For more information on fair use, again, I put a link to a really wonderful set of webinars that Meredith organized in the chat. There's also a recording from Sarah's webinar last week. So she addresses fair use there as well. And if there are other questions, please just keep them coming.